Greetings and salutations. Welcome back to another episode of the Legal Beagles. Today we're updating you on Kurt in Seattle. Where to begin? There's so much going on. I'm going to start with Monday night. By Monday we were able to get Benny's habeas corpus into the Western District of Seattle. They assigned it to Judge Whitehead, who's a defendant in one of Kurt's civil cases, and he hasn't done anything with it. And they labeled it, of course, the clerk has labeled it a miscellaneous case rather than a habeas corpus. And so I've had several rounds calling for Benny with the clerk, and they're doing their best to do a little runaround. They've always acted frustrated. Oh, we know Mr. Benshaw files a bunch of stuff in here, and he's just going to have to do it himself. And I've explained to them that he can't because they won't allow him to. And two, we have every right to file on someone's behalf a writ of habeas corpus under Washington state law, which I was happy to quote. Of course, they really didn't want to hear that. They got it filed as miscellaneous. They sent it to Judge Whitehead, and he hasn't done anything. So we got on Tuesday, we got Benny the right to e-file because they were demanding that he has to file anything else, like a recusal for the judge, that he'd have to do that in person, have to come from Florida to go to Washington. And so with Benny's disability, he's deaf. I'm able to call and negotiate these things and let them know that they're violating the American with Disabilities Act by delaying filing because of an administration procedure, etc. So the next day they could have done it Monday night because I called them in time, but they were very disgruntled and they had pressing business to do, and so they did it on Tuesday. So then Benny filed a recusal of Judge Whitehead, which has been filed into the case, but nothing has occurred. In the meantime, Kate filed his, which I read to you the last update, in the Ninth Circuit in the Court of Appeals. We found out late Tuesday night that they had filed it as a habeas corpus, and we thought that they were going to take it up the appellate court, snatch it from Jamal Whitehead. But upon reading the order that they issued the following morning, they are going to send that back to the Western District to Whitehead. And so at least it's labeled a habeas corpus. In the meantime, someone else has filed a habeas in state court trying to get him out. And so during all of this happening, they have restricted Kurt's phone calls. So everyone that he's called, me, everybody else, they've just blocked our number. They can't call. And so I'm going to let you hear this recording from Kurt that we got on Tuesday. And there's a lot more updates to come. Please stay tuned or fast forward. We're going to end this with his city court hearing that occurred yesterday. And so that's a pretty interesting little tidbit of what happened there too. So make sure you at least watch that, but have a couple phone calls to get through with you, and then we'll go into that and give you a call to action of what we need to do. So with that being said, here's the first call, which we thought would be the last call. Kurt.
Hello?
Hello. Happy
hi.
Tuesday.
Happy Tuesday. What's up?
Okay. Well, so this could be the very last call. So I just want to give you a heads up. I had to call from somebody else's phone number because since we talked this morning, the Idiocracy Board has every number that I call. It says this number is restricted. This number is, so basically I can't call anybody. And the only way I was able to call you is by having another inmate dial the number, but they may catch on to that. So when I say
Okay.
this may be the last call I'm able to make out, I mean it may be the last call I'm able to make out.
Wow. Okay. Also, just in case, be careful with your friends in a slammer, meaning that don't trust anybody because sometimes they use them as.
Oh, I know.
You know.
I know.
Yeah,
I know
okay,
all about
okay. Yeah.
the informant
Okay.
game. Yep.
Yeah.
I know.
Okay.
But thank you for the heads up.
Well, it just came to my mind, and I thought that I would
I
mention that.
already had my eyes on somebody who very well may have been, but it's no. I'm on top of all that, and it's no concern.
Yeah. You're smart. Good. Good.
So, but I did
Okay.
also want to pass on a quote from a case that people may find useful regarding the first 8 amendments being incorporated through the due process clause of the 14th.
Mm-hmm.
And so that case is Gideon, Gideon v. Wainwright, Wainright, 372 U.S. 335. It was from 1963. And the quote from page 343 is, certain fundamental rights safeguarded by the first 8 amendments against federal action were also safeguarded against state action by the due process clause of the 14th Amendment. And then it quotes Gross-Jean, which is Grosjean v. American Press, 297 U.S. 233, 1937. Now, just the only word of caution on that is there's multiple clauses to each amendment, and so people should read that case because there are some distinctions where they get into the details about which clauses of which amendments are explicitly safeguarded and which are still a point of ambiguity.
Okay.
Other than that, happy Tuesday.
Well, stay strong and positive. Yeah, well, I mean,
Stay strong.
it's,
No. It's like the willow. It's stay flexible.
that's true. That is true. Yeah. Thank you for mentioning it. You're right. Be flexible. Yes, absolutely. Be flexible.
And, yes, so tell everybody hi. Tell them I love them.
Mm-hmm.
And maybe we'll talk again. I don't know. But I had a good life if we don't talk again.
Well, no. Don't think negatively. You still have a good life, and you're gonna come out.
No. That's not a negative thought. That's more of the Tibetan, like, always be prepared to die so that you can truly live it every day.
Well, that's okay. Excellent. Nice explanation. But stay flexible and positive.
It's hard. It's hard to be. It's hard to be rigid when you're laughing. So I'll leave it at that.
Yeah. No, that's good. That's good.
Okay.
Yeah. All right.
I'll talk to you soon.
Talk to you soon. Mm-hmm. Bye.
Bye, Dean.
Bye. Bye. The call.
Now, is this not amazing that they don't want the man to call? They don't want to give him pen and paper to defend himself. They want to assign him a public defender that won't do anything. Except now they want a psych evaluation. We're in the background doing what we can, but we're going to need people to call the Western District Clerk's office and ask them why they haven't ruled upon the habeas. I'll put the number right here, 206 number. You can push 0 at some point and get to someone. I think the first 5 prompts are irrelevant. I don't know if you have to wait till the first 5 prompts go through to hit 0, or you can hit 0 immediately. I don't know. But the case number for this is 24-MC-43. Let them know that the Ninth Circuit has sent a writ of habeas corpus. They know it's a writ of habeas corpus now, and they must rule on this. And we want to know why he hasn't ruled on it or ruled on his recusal. That should be something you know right away. You're a defendant. You're a defendant in a case that the Kurt brought, and now you want to rule on his freedom. We don't think that that's really appropriate. So I've got another call. He talks a little bit about some court case that he wants to highlight, and I will provide that in the that first one in the Wainwright, Gideon versus Wainwright. I'll put in the description. But in the meantime, I'll let you hear this.
All right, we're recording. Good. This is good news. You're calling.
It's Happy Wednesday.
Happy Wednesday. There you go. That's what it is.
Yeah.
It's about the
Yeah,
Wednesday.
I don't
So
know
what
why,
happened?
It just started working again. So
Well, you know what? That because you got to call out. That's my guess. Hearing this right now, the fact that you were able to get the message out by somebody else, and I was able to record, would have been a really bad for them.
yeah.
So that tells you that the outside pressure and you getting certain things out of how they're violating your rights is having an effect.
For sure, yeah. For sure.
Yeah, so that's good.
Yeah, and so I was thinking about a follow-up to the FBI would be a follow-up to the Department of Justice. And, you know, the ironic thing is the U.S. Attorney's Office is in the same building as Western District Court here in Seattle at 700 Stewart Street, right? So, and I tried doing the online and calling to get a civil rights complaint going with the Department of Justice multiple times last year, and they would respond and say, you know, oh, we're not gonna do anything with your case. But I even tried emailing the email addresses of DOJ attorneys I could find, because there's this case. It was initiated in 2012. It's United States v. City of Seattle 12-CV-1281-JLR. I'm pretty sure that's it. So that's the one where the United States sued the City of Seattle because there were so many reports of biased policing and excessive use of force by the Seattle Police Department. And so that's the case where I tried filing a motion for leave to file an amicus curiae brief last year, and Judge Robson, he denied it because apparently I missed the cutoff for something like that by like 5 weeks. But what I did was, when I found that case, I got the list of all the current and previous DOJ attorneys who were supposedly litigating the case for the United States, and I provided them with my first federal lawsuit against the City of Seattle. So all of those fuckers know exactly what's been going on because I provided them with the information, and they refused. They showed zero interest, right? Which is what told me at the time. I'm like, oh, this whole fucking thing's a dog and pony show for the public to make it look like the DOJ is actually addressing biased policing and excessive use of force. Because, you know, where are we now? I'm subject to 4 years of biased policing, and they fucking firebombed my house, basically.
Yeah.
So, you know, much like the strategy with the FBI, which is, you know, it's one thing if I call, but if 10 or 20 other people call, it's going to look really bad, really, really bad if anything happens to me, or if the media gets a hold of this before they take any action, because then the media is going to be like, so why did you sit on this issue for a year and do nothing? That looks really fucking bad.
Yes. Good point. Very good point.
And, the other thing is, I'm not planning on going to the Bread and Circus show in Seattle Municipal Court, which I think it's 12:30 or 2:30 Pacific time. However, that's not to say that they're not just gonna like bring 3 guards in here, pick me up, and drag me down there.
And
so,
drag you there.
I don't know, but I didn't want, you know, like 30 people to log on and then me not be on there, and people be like, why did they fucking log on for this? Ben Shoof's not even on here.
Yeah. That's okay. That's a good, I think that message was there, but we should be ready to stand by.
Regardless, it would be good to get a recording of what they're actually doing in there today.
Correct. Correct. Yes.
Because the public defender, Reagan, he's a decent dude, but they're still all playing the game. They're pretending that the computer system filed a notice of appearance on their behalf, and they have no control over that now, and it's totally in the hands of the judge, and it's not their fault. That's the game.
Well, this is against your rights. It doesn't matter what is in the system pulls out. You said to the judge, I never consented to have this particular attorney. There's nothing to fire because I never hired her or him. So that is done outside of jurisdiction, and this is a violation of your constitutional rights.
Right.
To an attorney of your choice.
There and saying that because the judge is just going to. He said the judge that's presiding today is Faye Chess, and that witch hates me. She's the one that issued this $250,000 arrest warrant.
You know what? I'm just thinking about it while we're talking. Maybe you should make appearance today and put on a record that you are hoping to find an attorney of your choice, counsel of your choice. You have friends attempting to do that, and until you will talk to your counsel of your choice, you're pleading fifth and anything, and that will go on a record, and it will also be applicable to your mental evaluation that they're forcing upon you. It will also add the legitimacy that you are pleading the fifth, so they cannot say that you're crazy and refusing to respond, because that would be logged in today's hearing. So I think it's a good idea to go there and put that on a record.
I see your point, yeah.
Don't you think? You have only a lot to lose. A lot to win if you put it specifically on the record that you are currently searching for a counsel's representation.
Right. No, I get your point because, in a way, if I'm not there, they can just say whatever into the
Exactly.
record.
They just think, he didn't take his meds or whatever.
Right.
Yes. So don't give them the opportunity. And you're pleading the fifth. So anything that they're forcing upon you would be done in violation of that, and it will be a violation of your Sixth Amendment right. That's a big one. That's a federal one.
Wait, how's it a violation of my Sixth?
Because if they're forcing you to speak or say anything without a counsel, when you specifically state to them that you are currently waiting to get a counsel of your choice, which you cannot pursue yourself, but your people, friends outside that are attempting to do that for you. If anybody forces you to speak without a counsel, that's a violation of your Sixth Amendment right.
Right.
That's how I see it.
Good point.
Yeah.
I like that strategy.
Yeah, so put that on the record. So not only are they violating the Fifth Amendment right, but also the right to counsel. That's going to be big.
Yeah, and
from experience.
The other thing I wanted to throw out there is just for people who might be writing stuff, and also with any calls to the Department of Justice, I think it's a good idea going forward to establish the groundwork in any sort of communication that the DV stuff arises out of the mask stuff, because, to give the context for the retaliation, right? Because, it started off with violations of the Civil Rights Act and the City of Seattle prosecuting me despite all of the case law saying that, I just found this case with some great wording. It's State of Georgia v. Rachel, Rachel. It's 384 U.S. 780, 1966. Actually, hold on. Let me grab the other piece of paper just a sec. So at page 807, it is the right of equal service in restaurants, and of course this would be public accommodations, and the right to be free of prosecution for asserting that right, not the right to have a trespass prosecution reversed, the present prosecution threatened, right? So this is the whole point, is all these Yahoo judges are like, well, you can appeal whatever we've done, and it's like, no, that's not what the Civil Rights Act says, and that's not what all these Supreme Court cases say. Like, you're prohibited from even prosecuting. Like, I have a right to be free of that. And so if this gets tied together, because the first judge to issue one of these failure to appear arrest warrants in Seattle Municipal Court, when they were like, well, you either have to put a mask on or we're going to issue a warrant. You have to come in with a mask on. That was Judge Anita Crawford Willis in July of 2021. She's Facebook friends with the former family court judge, David Keenan, because I found them on their Facebook accounts, right? And so she threatens me with arrest, issues a $10,000 bench warrant in July of 2021, and then it's only 90 days later that Keenan's taking my son away because I'm a crazy anti-vaxxer, anti-masker, right? Like, this is small town here, girl. And so, like this case that I just cited, it's got some good stuff, especially, around 806, 807 that I was reading today, the state of Georgia, Rochelle, I don't know. Just to show that, because this case also, it's talking about removal to federal court. That's why I started looking into it, because it's under 28 U.S.C. Section 1443, subsection 1. That's what the case is about, but it's also going over these discrimination cases, right? So it's perfect for mining some quotes for what's going on, just to establish that everything that's going on, right? This stuff didn't happen in a vacuum. It's just the escalation of retaliation against me for trying to seek redress.
Yes. Now, let me ask you, did they ever, somebody asked last night, did they ever offer you any opportunity to bail you? Any conditions like wearing GPS cuff or anything?
You have 1 minute left.
Oh, yeah. Well, I'll call you back if it cuts off.
Okay.
Yeah, if I can bail out, so both the King County warrant and the Seattle Municipal bail, even if I can come up with bail, they're saying I have to do electronic ankle bracelet home monitoring.
Okay. So that was told you that you would be doing. That would be the condition. Okay.
Yeah.
Yeah.
Do you want me to call back? Do you have more questions?
No, I think that's good right now.
Okay.
And I'll just say that tomorrow I have a iffy day. I will not be able to call or record anything before 1 o'clock. I mean, anything after 1 o'clock.
Okay.
And if I don't pick up, try again. And then I have ability to, I think, between 3:30 and 5.
You mean your time? Your time?
Yes. Yeah, my time. Yeah.
Because
those will be the times that I will potentially not have access to the phone.
Thank you for using Securus. Goodbye.
So we're thankful that something has occurred, whether it be in the habeas in state court or the Ninth Circuit drawing attention or whatever. They've reopened his phone calls, so at least there's that. We're still trying to find out if Judge Young from the first day actually ordered a psych evaluation or they're just bluffing. And he talks about this in the next phone call. And so I'm going to let you listen to the third phone call.
Oh, happy Wednesday.
Happy Wednesday.
So I had a couple questions.
Yeah.
Did anybody check the docket of the King County Superior Court prosecution to see if the judge actually entered an order?
For your mental evaluation?
Yeah.
I am not aware of whether somebody has or has not as of yet.
Okay, because that would be an interesting thing to check. Because she may have just been bluffing.
That is true.
Right.
Yes.
And because I was thinking through this. Oh, so I should say one more thing, which is there is no way for me to make an attorney call from here. Be able to enter something on her end to make it an attorney-client privilege. I checked with somebody in here who has an incredible amount of experience, and he confirmed that my supposition is correct. There is no way to make a private attorney call from here, which means we have yet another violation of my due process rights because I literally can't talk to an attorney.
Interesting. Yeah.
Right?
Yes.
Okay. So here's, regardless of whether or not the judge actually entered a order yesterday or not, here's what all of these ridiculous violations of due process are indicating to me. They have no intention of ever actually following through with the prosecution. Like, this is just further fucking bluster. Just like, because you weren't around, but back in September of 2020, after my second arrest, which is when I went to the parking lot and called 911 to report the police for unlawfully imprisoning me, that's when they arrested me, kept me for 4.5 days, and they filed a $100,000 bail along with the felony weapons charge. Within 24 hours of me paying the bail, they dropped the charge. Right? Like, this just, it just smells like the same bullshit, except they've turned it up to 11 this time. But, you know, as stupid as they are, I've told them over, and I've mocked them literally for months and months that, like, what are you going to do? Take me to trial so that I actually finally get to put Jessica Owen on the stand and prove beyond any doubt that this is all fraud? I'm like, you guys can't do it. I know it. You know it. Right? So,
so
know, there's nothing else
supposition
that really makes sense. Right? And I think that's why Whitehead and the district court clerk are, you know, playing like hide the football and trying to slow roll the habeas, is they know there's no grounds for any of this. So the only thing they can do is just delay and come up with ridiculous little delay tactics like, oh, we're going to do a mental health evaluation, right? Like, they got nothing.
I think that's how it sounds, what you're saying, that the only hope of things going away is to turn you into a mental case. So anything and everything you say would be discounted, and you will be put on a forced treatment, and your life is going to be ruined, and whatever you say is going to be always suspect because you're mental case, supposedly. So that
and my jokes will never be funny ever again.
Well, they could be funny, but nobody will take them seriously.
Well, I hope not for jokes. But just so you know, they're continuing to violate my religious rights. I mentioned previously, I've sent out these paper requests, which is the only way you can make a request, for a prayer mat, to see a chaplain, for a headdress, all of these things. They're never going to provide it. They don't give a fuck about my religious rights. And they do this game where they force you to choose between your wearing religious raiment or appearing in court. You can't do both. And so yesterday I was like, you know, because religious freedom is, I think, Article 1, Section 7, and right to appear, I believe, is Article 1, Section 22 of the state constitution. So, and I tried talking to the bailiff in charge, or whatever his title is, and I was like, look, you can't force me to choose between two rights. So yesterday I went along with it. Today I'm going to take a stand. I'm going to stand firm on my religious rights, and I think they're going to deny me my right to appear in Seattle Municipal Court because of my exercising my religious beliefs. So if you don't see me in court, that's why, because I'm not going to continue to have my religious rights and freedoms violated.
It is going to be your, how would I put it, right to do and decision to do what you want to do. If it was me, I would go and I will put that on a record. Not only were you violated with X, Y, and Z, but they are also choosing you to relinquish one right in favor of another right, and you felt that you had to appear to court to put these violations on the record.
Now, I realize that doesn't constitute legal advice because you're not an attorney. I haven't hired you
Yeah.
as counsel, but I do have a right to speak to my friends.
Yes,
and
you do.
give me their opinion.
Yes. So this is my opinion. That's what I would do. Yeah.
You have a very sagacious opinion, I must
What?
say.
Sagacious meaning?
Sagacious, that means wise. Think
Oh,
of
thank you.
sage, and then it's an adjective, so it has a
Okay. It's some things go over my head. I'm not that bright. Which
No,
is
no,
okay.
no. It's English isn't your first language. Give me a break.
Yeah. But I think I have common sense, and this is what I would do. And that was because right now the only one that would know what is happening would be me and this recording, and it would be hard to put that on a official record because it has to be somehow submitted as evidence during procedure. But you being at the hearing, you get it right there on an official record. Boom, done.
Right. Okay.
Yeah.
I see the wisdom in that.
Yeah, I think it would be something that I would do.
Okay. And if you can just, next time you talk to anybody, if you can just have somebody check that King County Superior Court case number 24-1-02680-7. Because if she issued an order, it should be in the docket.
You're correct.
Like that stuff goes in right away. Just a curiosity.
No, it's a very good point.
Okay.
Because yes, nobody has better points than you because you are in a thick of it and you know all the intricacies and details of your own case better than anybody else. Everybody
I have
else
a front row seat.
Exactly. Everybody else is just catching up, looking at your stuff because nobody has ever looked at your case remotely as closely as they are forced to now in order to petition for habeas or anything else.
Yeah, I can only imagine, what a fucking nightmare for people. Cause
yes.
It's huge.
It is a nightmare. And you have to also understand that most people have their own lives and their own things to go on in addition to trying to help you. So, yes, exactly.
For sure.
So
that's why I'm grateful for anything, and I am.
And I am not saying it in any negative way. I'm just saying that, yes, your case is extremely complicated and a lot of information and details. So that's why it is perfect that you have this ability to record whatever you direct or provide the information, which is, I think, invaluable. You're still in charge of your own case, so to speak, in this way.
Yeah. So I will then most likely go and get the religious discrimination on the record, the due process violation of my right to an attorney, the fact that I'm trying to get an attorney and I'm being denied that right and ability.
And that you're going to invoke your Fifth Amendment right at any procedure that even remotely resembles the mental health evaluation or any legal questions that they will present to you because you will exercise that right.
Yeah, and because I was talking with one of the guys in here, I present an interesting scenario they're not used to, which is, as a pro se person, I would be able to make my case and communicate everything I wanted to communicate, either directly with positive statements in my introduction or in my closing statements, or inferentially through my question of people I was subpoenaed to stand, and I would never actually have to take the stand myself. Correct.
You would not be, because that would be otherwise incriminating yourself and violating your Fifth Amendment right.
Right. But, and it's not that I wouldn't be more than happy to get up on the stand, because I got up on the stand once in a case several years ago because I was like, I want to get up there and tell my story. It's just that I don't need to, and it presents a hell of a problem for them because their witnesses I can shred if I put on the stand, and then they have no opportunity to question me.
Which provides them the motive for bad people to make sure that whatever you say would be considered as somebody that is not full in their capacity, which is where the mental thing comes in, which is a very interesting angle that they have sought to use against you. And what I understand and what other people are investigating and reading the statutes, the whole arrest, they don't even have the right to hold you. They potentially did not have any right to arrest you.
Oh, 100%.
Yeah.
Yeah, because they.
So.
Yep, 100%. They didn't have the right to arrest me. They didn't have the right to issue an arrest warrant. They didn't have the right to get a search warrant.
And they do not have the right to hold you, and they do not have the right to force you to any treatment, medical or otherwise.
Well, yeah, I wish they would provide me with dental floss. That's the one thing I'm really missing in here is they have these little 2-inch long toothbrushes that are almost impossible to brush your teeth with, and then no dental floss.
Well, but, I'm sure they have a dentist that is gladly going to pull some of your teeth if necessary.
Yeah, so I don't know which constitutional right my right to dental floss is protected under, but have people research that.
Yeah, well, that's something interesting to explore, I'm sure.
Yeah. Mm-hmm. Okay, well, hey, I'll let you go.
Okay.
Tell everybody hi.
Yes,
okay.
Thank you, Kurt. Okay, thanks. Mm-hmm. Bye. See you.
Now, the last piece of business we have is his hearing yesterday in the city municipal court. And it's quite interesting. This slimy judge is also a defendant in one of Kurt's civil cases. But she didn't reveal that. I mean, obviously she and Kurt knew this, but she didn't reveal that to us until the end of the hearing when she ended up recusing herself. So we've got them a little bit pushed on their heels, but we have to keep the pressure up. We need people to be calling local newspapers and TV shows. If you know a big YouTube channel or some other, civil rights auditor, the civil rights lawyer, we're trying to reach out to him. There's any number of people that are doing this type of work. And so if y'all know of any, please contact them, get them some information. We're trying to get a little overview script for people that we can post, and y'all be able to read it. But you know enough to know that rights are being violated. The writ of habeas corpus needs to be filed and needs to be, reviewed and ruled upon, so we can either appeal it to the Ninth Circuit or we can get him out and get him in writing his own stuff, because it said it's enormous, all of his cases, and the best person to do that would be Kurt. So I'm going to end this with his hearing. And please, if you feel compelled to call the FBI, the DOJ, your representatives, senators, any of these things, take an initiative here. There's a lot going on that we're busy with in the background too, trying to get these things put together to get it out to you guys. But there's people writing stuff for the habeas, we're trying to get them file it properly and rule on it. And so we need some of you guys to start calling the Western District of Washington, which is in Seattle. Press the 0. You can talk to a representative, and then just be polite, give them the case number, and I will post that with the phone number. As you saw the phone number earlier with case number, and I'll try to leave it up here. But call them, ask them why a writ of habeas corpus with a man illegally detained and being deprived of constitutional rights is being allowed to sit in jail while the Western District of Washington sits on their hands. This is inexcusable, and they know it, and so we need to let them know we know it. So I'll leave you with these with the court hearing, and it's interesting. It's certainly interesting. This is gonna be fireworks here before it's over. So can't wait to get him to a place that he can handle his own stuff. But here we go.
Okay, are we ready on the next case?
Yes, Your Honor. Next matters we can call are the Kurt Van Schoof matters. These are cases numbers 676207, 676175, 675405, 656-748, 656-749, 669329, 676463, 676216, 676492, and 671384.
I'll address it.
Okay, counsel.
So I'm the only counsel on this case, Your Honor, and pro se Kurt Benshu. There appears to have been an error on the part of the Department of Public Defense by which Mr. Reagan, Roy, I believe his name is, was a notice of appearance was filed on his behalf in case number 675405, despite my repeated communications by phone, by text, and by email to senior management at the DPD to demand that they stop assigning attorneys to my case to violate my rights. So I'm not pointing any fingers or blaming Mr. Roy, but the notice of appearance filed on his behalf was inappropriate and illegal.
Well, no, not illegal. Because everybody has a right to counsel, and so because of that, attorneys are assigned to individuals who qualify as needing assistance if they can't afford an attorney on their own, or they want to proceed pro se. Mr. Bishop, you have quite a few cases.
I have objection, I have quite a few malicious prosecutions.
Okay, so no, I'm not going to characterize them as that, but if you'd like
Well, that's
to,
a
but
fact.
I'm just saying is you're facing quite a few charges, and Mr. Roy, our DPD, might not be aware that on the majority of your cases that you have been representing yourself. So with that
we've had
being
conversations.
with that being said, is I will allow Mr. Roy to withdraw, to put in a notice of withdrawal, and we will continue to handle your cases because, as I said, the majority of the time you have represented yourself. Okay, so Mr. Roy?
Just to be clear, Your Honor, does that mean Mr. Benshew's request to go pro se on that case is granted?
Is granted, yes.
Thank you, Your Honor.
And Mr. Benshew has gone through the colloquy. He has been very expressive. He has represented himself in front of me several times on his other cases. So I know he is aware of the colloquy on when not wanting a counsel to represent, and that he feels confident that he can represent himself. Am I correct, Mr. Benshew?
I believe so, and so am I correct in my understanding that the court acknowledges that I am competent to proceed based upon past litigation?
Yes, because you've gone through the colloquy before, understanding where the judge asked you, do you understand about this case? Do you understand you'd be representing yourself? You're expected to act as your own attorney. You will not be given assistance. Do you recall that, or do you need me to go over
I
it again?
fully recall that, Your Honor, and I would note for the record that there is a serious contradiction between this court and King County Superior Court, because just yesterday I was prevented from proceeding pro se when the judge claimed that that she had concerns that I was mentally incompetent, and she delayed the case another 14 days until the 31st, and allegedly is ordering a mental health evaluation. So there is, there's.
Her perception of
You
my,
might want to get on the same page.
no, we don't have to. We're in a different court. We're both independently elected judges. I'm very familiar with you. I don't know what her familiarity is with you. What one judge decides does not impact what I decide, depending on what stage we're at, but it's particularly that's Superior Court, this is municipal court. So with that being said, as long, I have not gotten any indication that you are not understanding. The law allows her, if she believes that you may not be able to represent yourself, to do what we call a 1077 and have a competency hearing where you would then be interviewed by a mental health evaluator. So that's her process. So now, since you are finally here and you have these cases, how would you be proceeding on them?
Well, first I'd like to address the two initiating cases, 656-748 and 656-749, both of which are a flagrant violation of the Civil Rights Act of 1964.
Okay,
Go through
I'm not
cases
trying
such
to
as
be
Campbell,
rude
City of
here.
Rockville.
Okay, you know, Mr. Benshaw, this is not the hearing for this.
Actually, it is,
We are,
because
no.
jurisdiction is a threshold matter, Your
no,
Honor. You know that, I know that.
Stop, Mr. Benshaw, I'm not going through this with you. I'm trying to tell you this is not the hearing, not that you can't make that argument. This is
It is. Jurisdiction is a threshold matter. These are
Okay,
malicious
Mr. Benshaw.
prosecutions. I came
Okay,
down here,
Mr.
excuse me.
Benshaw,
Excuse me.
stop.
You
No,
don't have
it's not a
jurisdiction.
stop.
You
I
don't
am
have
the judge. I'm
jurisdiction.
trying to tell you, we are not gonna argue about jurisdiction today. It's pretrial hearings.
I'm not arguing.
No,
telling
I'm trying
you
to tell
facts.
you is,
I came down here to remind you that you don't
No.
have jurisdiction. I came
Mr.
down here.
Benshaw,
No, let me
Mr.
talk. I
Benshaw,
waited in jail
Mr.
for
Benshaw,
14 days.
no.
I have had my religious rights violated.
Mr.
I've been
Benshaw,
denied phone
if
calls
you
to an
have
attorney.
arguments, this is not the hearing to raise constitutional.
Objection. You do not have
arguments.
jurisdiction to speak. I will let you speak when I'm
Okay,
done
well,
talking.
no,
If
that's
I've
no,
been
that's not
interested in
how
what you're
this
saying.
works. I do
So
have
first of all, in
jurisdiction.
case number
Mr.
656,
Benshaw, we've
748
concluded this
and
hearing.
656,
We've concluded this
749,
hearing.
this
Mr.
court was
Benshaw, we are
prohibited from
concluding,
proceeding against me.
we
I
are
will
concluding
cite
this.
several Supreme Court cases.
We are concluding this hearing because you've decided you are the judge
No.
and that you are moving. I've tried to tell you, this is a pretrial hearing, no motions for dismissal or lack of jurisdictions
Okay,
happen
and I'd
at
like to-
pre-trial
I'd like to
hearing
note
calendars.
For the record, certain
So-
conditions in
so
the
hold
jail
on.
that are violative of my
Hold
due
on,
process
if
rights.
you would let me talk, I'm gonna try to tell you very politely. Pre-trial hearings are either to set this matter for trial or to continue it while you still do investigations and negotiations with the prosecutor's office. If you set this matter for trial, then we will set motions hearings. At those motions hearings, you can make the argument of lack of jurisdiction by the court, lack of constitutional, and lack of constitution in whatever area you think that we're violating the Constitution and other matters. This is not the hearing in which the court will consider lengthy, long, ongoing motions hearings. This is not the time. So the question I have for you before you begin is, are you either setting these cases for trial, so you can therefore then make those arguments, or are you continuing because you need more police reports, discovery, or to negotiate with the city on these cases?
I offered to negotiate with the city. I offered that if they would stop the malicious prosecutions and the RICO enterprise and stop violating my rights, that I'd be happy to do a global resolution. I offered that repeatedly to Dallas Lake Pierre, who was representing the city in case number 2:24-CB.
That is a civil matter.
I understand, but in that civil matter, there were criminal law violations alleged and evidenced perpetrated by Katrina Allen, Sahila Serafan, and others. I won't mention anybody that's in this courtroom. So there is no need to set this for trial because the court doesn't have jurisdiction. I don't have any more need to do investigative work. I have all the facts of what's been going on. The court does not have jurisdiction. The prosecutor is engaging in a malicious prosecution. And it's noteworthy that neither Ms. Katrina Outland nor Ms. Sahila Serafan are here. They're both defendants. I caught them red-handed in perpetrating this RICO enterprise. The court does not have jurisdiction for the quote-unquote trespass cases and Supreme Court case law. There's no question. In fact, it's laughable. This court has proceeded in maliciously prosecuting me in those cases for nearly 4 years. As far as the DV cases, which are all the other ones, this court never had jurisdiction because under RCW 7.105.050 subsection 1 parts A and D, only King County Superior Court could exercise jurisdiction in the alleged violation of the allegedly valid restraining order that was issued by Judge Keenan. this court also violated the priority of action doctrine. When another court asserts jurisdiction, they have jurisdiction. That's also what happened when King County alleged that they had jurisdiction in the family court proceeding. I have shown in court over and over and over again that the mother of my son, along with her prostitute perjurer girlfriend, they committed perjury, foundational to Beatricely initiating case number 21-5-00680-6, along with
Okay,
collateral
so
and
Mr.
extrinsic fraud.
Bishop, not trying to cut you off, but I am not gonna base a ruling. Since I am a defendant in your action, I'm gonna recuse myself from hearing anything further because you're bringing in that civil matter which you have named me as a defendant. We're gonna try to find a judge who has either has not been identified as a defendant in your civil case or has not had your case yet because the circumstances of which your cases have moved through this courthouse. So at this time, I'm going to stop, exclude speedy trial. We're going to get you a date, and then I'm going to try to find an attorney who will not have any bias or anything else in regards. Okay.
Your Honor, I did just want to note that this was going to be a city trial set, but given
He's
that-
not, if you're, it doesn't matter what the city is going to do here at this point. He does not want to set this matter for trial. He believes at this point that the court should make a ruling on his arguments. The court is not making any rulings. The court is recusing itself because I am a named defendant in the civil lawsuit. So basically, all I'm doing is punting it to the next judge that we can find.
And Miss, I don't know what your name is. Miss Prosecutor. Hello? Yeah, are you aware, sorry, I didn't know your name. Are you aware that a motion for removal to U.S. District Court has been filed under 28 U.S.C. Section 1455 to remove all of the cases in this court as well as the King County?
That's a civil matter. She is a criminal prosecutor. She's probably not aware. If I'm wrong, counsel, am I wrong? Are you aware of the civil lawsuit that I'm referring to?
I have no idea of this.
I was actually referring to a criminal removal under 28 U.S.C.
She's not familiar with all these. She does not practice except for in this court. Mr. Benshu, I'd ask politely that you not bring her in because I'm not making a ruling. She's not been on your cases before. There's no need to bring one more person into this situation. You've already identified prosecutors you believe have violated your laws and cited them in your lawsuit. So she knows nothing. She's not participated in anything. And at this point, she's not participating because we're not setting this matter for trial. We're going to get you a new judge and get you a new court date.
How far out should we set this?
Couple of weeks, because he's in custody. Let's try to get something, but we need enough time to get a pro tem, so at least a week.
A week, okay.
For the record, I wish to note that I've been denied all pro se materials. I've been denied phone calls to find an attorney or to speak with an attorney in private, as is my right. I've been denied pencils, paper, access to computers. My religious rights have been violated. I've had to choose between having my religious freedoms protected under Article 1, Section 11, and my right to appear in person under Article 1, Section 22.
So noted.
Your Honor, the 24th or?
That's fine,
Okay.
if that's a free day for all his cases.
We'll set all matters on July 24th, 1:30, back in court at 11:03.
I'm sorry, you said July 30th?
Or July 24th?
24th, okay.
And I would note for the record that the ongoing malicious prosecutions are a violation of 18 U.S.C. Section 1512. My religious computers and documents were seized from my home without a valid search warrant, and these prosecutions are clearly intended to infringe upon my right to petition for redress, as I cannot litigate any of the court actions that I have ongoing presently in state and federal courts.
Okay, thank you, Mr. Bishop. We'll see you back on that court date. It will not be me, but someone else.
Okay, happy Wednesday.
Okay, do we have any other matters that are ready?
Yes, Your Honor. The next matter we can call is the Jonathan Nguyen matter. This is